So I'm Gillian Hadfield. I'm a professor of law at the University of Southern California, also a professor of economics here, and I've been here about 10 years. Before that I was at the University of Toronto, and before that University of California, Berkeley. And I've been teaching this type of course using a lot of group methods and team-based teaching and problem-based teaching really for over 15 years. Started developing courses like this, having elements of this back in when I first started teaching at University of California, Berkeley in 1990, and seriously set about developing the courses that I teach now in the mid-90s at the University of Toronto. So my course, Advanced Contracts, is really designed to throw away our doctrinal goals for an upper year course and really focus on developing students, lawyers who understand what the job is of helping clients solve a problem. So the course is designed, there are no assigned materials, there's no casebook, there's no set of readings. The only materials that we use in the course are a series of 8 cases, which are more like the business school type cases that people might know about. Here's the situation you're facing. We included some redacted documents, so it might be contract drafts, exchange of emails, letters, and so on, or quotes from people. And then we basically have students work in teams, and their assignment is you're meeting with your client in a week, go. And so the students at that point have to figure out, right, with just that material that they would have, what is it we need to do to solve this problem. But the thing you can do in a setting like this is students, like I say, there are 8 of these over the semester. In an ordinary class, I'd have 32 students, for example, 8 groups of 4. Each of those groups would act as attorney groups for 4 of the cases. And then I have the other 4 in a setting play client. And what that setup gives them an opportunity to do is basically they get an assignment like this, they take a stab at it, they see how it works, go back, do it again with a different set of materials. So that it's this opportunity to try solving a problem, see how it went, get feedback, think about what you might have done differently, if you got your group to work better, if you hadn't gone down those rabbit holes in research, if you had really focused early on what the client was interested in, and do that again so that you have enough interest in the course. You're not just doing the same problem over and over again, but there's enough that's comparable in the structure that students getting practice over and over and over again to apply the lessons that they're learning from doing it themselves and watching their classmates. I think that's different from the clinic setting. It's creating an opportunity for those kinds of apprenticeships without sending people out into the real world with real clients, without sort of the intensity of actually having to deliver for a live client. And I think this is really important, and I think that people like Bill Sullivan and Pam Grossman and others who have done so much work on how you educate people in a practice. You practice the practice, and that's what we're doing in this course. The first time I taught this class, I just got a big wake-up call, which was, students were in teams working these materials like I've just described. You're the general counsel. Here's the document, the draft you got. Your client wants to know whether to sign this. They want to know whether to go ahead with this. And, just discovered to my surprise that the students, who were excellent students, smart students, really didn't know what the job was. They knew how to talk about the theory. They were really good at talking about the theory. And they could talk in general terms about the contracts or the contract problem, but in the way like a social scientist would talk about them, which is, in fact, what many of us are in law schools. But they didn't know the nitty-gritty of what is the client trying to accomplish, what do they need from you, and what materials can you look at, and how can you make a prediction about what's going to happen for them if they have that word in there versus this word in there. What will be the consequences if they stop paying their their bills? Do they have a basis in the contract that they can point to? A few years ago, I introduced a more structured technique for doing that, of having people take turns chairing the meeting. So 15-minute turns chairing the meeting. Really interesting to see how people, first of all, have no idea how to do that, and then how they grow into it. And to be honest, being able to do that's a pretty valuable thing, and it's the type of thing that's reflected as well in developing the skill for knowing what's important. Well, how do you think about what's important? It's not what you intellectually think is important necessarily. It's what's strategically important for your client. That means you better talk to your client and find out. You need input on that. You need to think about what's the likelihood of different kinds of outcomes. Which ones should you pay attention to? How do they interrelate? It's a deeply intellectual process. And most of our conventional teaching really doesn't get students to do a lot of that. So it's putting them constantly in the position of, at the end of the day, you're the one recommending a solution to your client. Take responsibility for that. You have to craft that. You have to help them make a better decision. If you just give them information, it's great. One of the students actually learn a lot from playing the role of client, because even though last week they might have walked in and spoken beautifully about, again, the parole evidence rule is always my favorite. The parole evidence rule, and you say, well, and maybe had somebody say to them, well, that's a matter for the judge to decide, right? It's a judge fact-based inquiry, and the judge will decide. And when they're playing client, they're saying, yeah, but are you saying that I can do this or I can't do this? Should I sign this or don't I sign this? And you can just see the light bulbs going off for people, that it really shifts how they understand what the rest of their education is about. I've had students say to me, until I took this course, I didn't know why we read all those cases, which is really quite a stunning thing in a law school, since they spend so much time reading cases. But they didn't understand that those were the raw materials for figuring out the solutions for their clients, and that they were documents you worked with intellectually, strategically, and so on. That's when I feel like I've done my job. It's really rare. I know a lot of people who think about teaching like this worry that they will have enormous difficulties. Honestly, it is just really quite rare. And the most recent time I taught this course, there was one group that just had a really significant ongoing set of issues, kind of a 3-against-1 structure. And at the end of the semester, to a person, all the people in that group said, I learned more from that difficult group experience than anything else. And I think that's taking seriously the maturity of your students. They know this is what the world looks like. They're not babies. And if you've dealt with them with respect, you've respected the fact that they are budding professionals. They're trying to be professionals. They want to know what it means to be a professional. Well, they will live up to it. They will live up to being a professional.